In this video, we're going to talk about arbitration. We're going to talk about making debt collectors who are trying to sue you in court go into arbitration. Everybody has been hounding me to make this video. So what I want to do is I want to make this video to allow you to understand what you are signing up for. Decide to take this route. Now, the prevailing benefit that other people have mentioned in their videos, and I've talked about it before, if you force arbitration with a debt collector, what you're hoping for is to get the debt collector to not want to spend any more money to go after the case. The trap, the catch-22, is if your case is worth a lot of money, and when I say a lot of money, anything that's going to be $4,000 and up, you have a very good chance that the debt collector is going to go ahead and pay the fee to go through arbitration. And even if it's under $4,000, with the way that debt collectors are filing these cases, they will still probably gamble on going under arbitration. The reason why is because they can get certain waivers. Debt collection companies, yes, can get certain waivers. Just like you can get a waiver if it was required for you to pay a fee to actually answer your debt collector lawsuit, you can actually get a waiver to not have to pay that fee with the court. A lot of people don't know that debt collectors can also get a waiver to not have to pay the fee. They can actually get a waiver. Let's just say that your debt collection lawsuit is what's considered past a small claims amount. Some jurisdictions also allow debt collectors to get a waiver to not have to pay what's called in my state a big money judgment fee, a big money claim fee. They can get a waiver to still pay the small claims amount, even though it's considered a big money claim. So you got to look at what's allowed in your jurisdiction. You got to look at the different exemptions and the different waivers that are available to debt collectors or even plaintiffs in your area. So with that being said, arbitration is used when the debtor against the debt collector is gambling, rolling the dice to see if the debt collector is going to go ahead and take it to arbitration, which is to pay the fee if they're required to pay a fee. So now what I want to show you here, this is straight from the CFPB website, so you can see if your agreement with and this is usually for credit cards or for loans, they're going to have in here, let's just keep it simple, for credit card agreements, all credit card agreements must be put on file with the CFPB. And you're able to review those agreements, and that's what they have to do to make sure that they're compliant. So they archive all of these agreements. So you can go to the CFPB and then search for credit card agreements, and you'll be able to see all of the different providers of credit cards. They have to put them in here. So you'll be able to see, just in case you don't have your original agreement, when they try to sue you, if they don't put the original agreement, which that is a problem because it's required, but you have to look up in your jurisdiction if you don't have that agreement so you can review to see if it is required for them, or that there is an arbitration section in your agreement. So now this is one that I opened up from Citibank, and let's just review. And this is probably the stuff that we don't all pay attention to except for the account, the amount that they're going to be charging for interest. And I know that none of you were planning on missing any payments, so you probably didn't pay attention to that. But they have here, stuff about the payments, authorized users, default, closing, suspending your account. All of this type of stuff can be used to make sure that they follow the regulations that are put in place and what they put in their contract when your account went into default, when they decided to close it, or if they suspended it. You can make sure that they were compliant with that. For the purposes of this video, we're going to stick to number 11 here, arbitration. Explains that you cannot go to court, have a jury trial, or initiate or participate in any class action if you have a dispute with us. And this is with this Citibank card, or Citi card, sorry, Citi card. So let's go to number 11. Let's go to number 11. So this section spells out exactly the rules between you and the original creditor if some sort of disagreement arises. Now, the thing that you need to pay attention to is if you decide to utilize this for an arbitration. So first, you want to look and see that there is an arbitration clause in your original agreement with the original creditor. And a debt collector has purchased a debt, and what you want to do is you want to roll the dice to see if the debt collector is going to pay to go to arbitration, because you have it stated right here that if there's any disagreement, that they must go to arbitration. So you might be saying, well, but that was with the original creditor, not with the debt collector. When the debt collector takes over the case, either assigned or straight out purchases the debt, but some of the times they'll say assigned in there. But when they take over the debt, they assume all responsibilities. Now, there's a section on here. Let me show you about assignments. Let me go back up here, because this is something that they try to get away with, where they try to throw in language that really just means that they sold a debt. They might say, well, what if we assign it to someone? It doesn't matter if you assign it to someone. If you assign it to someone, you sold it to someone. In this specific one, I don't see that it shows anything about assignment of the debt. They have some information about sharing your information, which is very important, but it does not say anything about assigning the debt. So let's go back down to number 11. So it specifically states here that this section provides that disputes may be resolved by binding arbitration. Arbitration replaces the rights to go to court. So just think about it. If you have a debt collector suing you for a debt that they purchased, and they don't want you to pay attention to this part here, arbitration fee, because that's something that they have to do, is that the original creditor has to pay for the arbitration expense. And that's something that a lot of the debt collectors don't want people to know about. Now, if the debt collector decides to pay the fee, so what's going to happen if they say, okay, well, hey, you want to force arbitration? We'll go to arbitration. So what's going to be the outcome there? Well, when you go to arbitration, it's going to be strictly between you and the debt collector on coming up with a settlement. You're going to forgive your rights to be able to take this to trial and to challenge the case as it stands. It's just going to be where arbiter is going to listen to their side, going to listen to your side, and you may be bringing up a whole bunch of stuff about that they had violations, that they didn't give you certain documents, they didn't prove the amount, charges, statements, all of that stuff. You're going to see and you're going to find out that the arbiter is going to be, okay, I hear you with all of that stuff, but we're in arbitration, and that means that we need to come up with a resolution. So I'll hear your side, I'll hear their side, and we're going to come to a resolution on the amount. That's what's going to happen. So don't let anyone else fool you. If they decide to go ahead and pay the fee to go to arbitration, it's going to be about the amount that you're going to have to pay. So that's the dice that you're rolling with arbitration. If you decide to go where you don't force arbitration, you respond to the debt collector lawsuit, you're rolling the dice that you can have the whole thing go away because you've submitted a response to challenge their entire case. So you have a chance of just winning outright without having to come to any settlement. And then let's just say that you get in front of a judge that sees it more their way. You still had an option to be able to settle the case even out of court if you feel like things aren't going your way. So in my opinion, and this is not legal advice or accounting advice, in my opinion, the best route is to evaluate your case and then submit a response to potentially win your case outright. If you have a case and you would like to get it reviewed, go to my website, thecreditrepairshop.com. We will review your court summons and all of the documents and let you know how we can help you, because we've helped our clients be able to win cases as much as $100,000. So just think about it. If you had a case for $100,000 against you and you went to arbitration, it's going to just be to settle that debt. What if the arbitrator says, well, let's just meet in the middle, 50%. That's $50,000. We've had clients who took the case all the way and won it for $100,000, and they didn't have to pay any amount of money. So, but that's a personal decision. So you can go to our website, thecreditrepairshop.com, and you can upload your summons for full review, and we'll let you know how we can help you. Please like this video, please share this video, and thank you for your time. This is Stephen A. Williams, President and Founder of thecreditrepairshop.com.